This is Chris McKaylee, and I wanted to talk about some of the general canons of statutory construction that we often use here in California. For purposes of statutory interpretation or statutory construction, the courts and bill drafters use a series of canons to help guide them. These include textual canons, which are referred to as intrinsic aids, as well as linguistic presumptions and certain grammatical conventions, and then the substantive canons of construction, which are and as well as some extrinsic aids. Now, it's impossible to list all of them, but the most common canons and those that seem to be most helpful or useful for legislative drafting are the ones I want to discuss. Now, we start with the presumption that the legislature drafts its bills carefully and intentionally. Because of this presumption, the usual approach of the judicial branch is to narrow statutes rather than expand them. And so the courts are generally less activist in their interpretation. The first canon, nocitur, osmosis, basically guides us to interpret words or phrases in light of the other words around it in the overall statute. In other words, we should interpret an ambiguous word or phrase by taking into account its use in the text. Some commentators have opined that words are defined by the company that they keep. So the following is an example. Each classroom shall be provided paper, binder paper, printer paper, cardstock, and colored paper. In this case, what's the first paper referring to? Under this first canon, again called nocitur, the first paper would be something related to binder paper, printer paper, cardstock, or colored paper, perhaps writing paper, but likely would not be receipt paper, for example, which doesn't really have anything to do with a classroom, and it would stand out given the context provided by the other words in that statutory statement. The next one is justum generis, which guides us to interpret catch-all phrases to be limited by the specific words around them. For example, former Justice Scalia asked what category would come to a reasonable person's mind. And his opinion was that this canon narrows a statute or the catch-all by the surrounding words found. The next canon is expressio unius, which provides that a list of words with no catch-all means that the inclusion of specific words suggests the exclusion of other words. The next canon is the rule against surplusage, which basically explains that different words in the same statute cannot have the same meaning. In other words, one word is not duplicative or redundant of another word found in the statute. The next canon is called the whole act rule, and that one provides that statutory provisions should be interpreted so that they have a whole coherent meaning. And identical words in the same or related statutes should also have the same meaning. The basis for this rule is that it assumes that the legislature has drafted purposefully and it's consistent in its word use. The next rule is that of the last antecedent, which provides that a modifier set off from a series of antecedents by a comma should be interpreted to apply to all of the antecedents. To put it another way, any qualifying words are to be applied to the words or phrases immediately preceding that qualifying word or words, and not be interpreted as extending to other words. Relatedly, we have the serial comma rule, which specifies that in a series of 3 items where each is set off by a comma, 3 or more, each item should be viewed as independent of each other. So here's an example. My favorite ice cream is coffee, mint chocolate chip, and vanilla with chocolate sauce. Compare that sentence when you say, my favorite ice cream is coffee, comma, mint chocolate chip, comma, and vanilla, comma, with chocolate sauce. In regards to interpreting general versus specific statutes, if a specific statute is deemed to be inconsistent with a general statute that covers the same subject matter, then as a general rule, the specific statute is usually deemed to be an exception to the rule that's provided by that general statute. In addition, as a general rule of statutory construction, the courts are required to construe an exemption in a statute narrowly. In a similar vein, a more recently enacted statute generally is given more weight than an earlier enacted statute by the courts. In other words, the courts say that if two statutes cannot be reconciled and they appear to be in conflict, then the more recently enacted statute will generally take precedence over the earlier enacted statutes. Another general rule is that statutes are presumed to operate prospectively rather than retroactively, unless there's evidence that the legislature intended the statute to be applied retroactively, and here the courts look for explicit language in the statute. Finally, the courts generally give deference to the interpretation of a statute given by an administrative agency that has particular expertise and is charged with interpreting or enforcing the particular statute. While this may not necessarily be a rule of statutory construction, it is important to take this point into consideration when there is an agency determination regarding the meaning of a statute. Now, substantive canons are presumptions that judges have drawn from policy and constitutional rules. In general, these canons reflect beliefs as to how the law should be. And there are essentially three types of these substantive canons: what we call tiebreaker canons, presumptions, and clear statement rules. The tiebreaker canons are used where there's a 50-50 split in interpretation of a statute. Here we have as a good example the rule of lenity, in which penal or criminal statutes whose purpose is to punish someone are to be narrowly construed or strictly construed in favor of the defendant, the criminal defendant. The purpose of this narrow interpretation is to provide adequate notice, due process, and fairness to the criminal defendant. Presumptions are the default interpretation principles that a court reads into a statute. In these cases, the opposing party must rebut or overcome the presumption. An example of this is the presumption that the legislature does not intend for a statute to apply retroactively. As a result, a court will generally interpret a statute to apply prospectively. So someone who is arguing that the statute applies retroactively must provide examples or aids demonstrating legislative intent that overcome that presumption. The clear statement rules are canons that the US Supreme Court has developed as an expression of what they call quasi-constitutional values. For example, under the constitutional avoidance canon, statutes will be construed wherever possible to avoid a question about their constitutionality. In such cases, the court doesn't have to find that the statute is unconstitutional, but they may raise a constitutional issue. And then finally, extrinsic aids are conventions that use sources outside the legislative process, such as legislative history, stare decisis, or the common law, outside the actual legislative language of the statute. And the courts here adhere to the doctrine of stare decisis, which is a Latin term that essentially means that a judicial precedent should not be overruled by a later court, absent some overriding considerations. It's important so that society knows how the laws will be interpreted and applied, and then we have consistency in court decisions.